Welcome, everybody, to Navigating the Legal Landscape of Community Broadband, presented by the American Association for Public Broadband and the Institute for Local Self-Reliance. I'm Gigi Sohn. I'm the Executive Director of AAPB, and I'm joined by my friend and colleague, Sean Gonsalves, who is the Associate Director for Communications for ILSR's Community Broadband Networks Initiative. That is a mouthful.
It is. It's a lot. You know, that's a lot. Thank you for that. Excited to be here. Now, last year, we had some super insightful webinars with special guests that were dropping some real gems. We had Building Smarter Cities and the Cost of Doing Nothing, Municipal Broadband and Innovative Financing Models. So we're going to drop a link in the chat where you can find those if you're inclined. But today, our guests are going to pass that bar. You see what I did there, Gigi?
Well, let me just for a minute chat about what we're going to cover today before you introduce our amazing legal experts. I mean, they're the top when it comes to representing municipalities who own their own networks or who are thinking about owning their own networks. I've known them for a really long time. We're focused on why legal and regulatory issues remain one of the biggest barriers and, frankly, sources of confusion for community broadband efforts. And this session is designed, not only for those communities that are, thinking about building their own or owning their own network, but also those, that exist already that may be facing or are anticipating facing legal challenges. So I'll turn it back over to you, Sean, to introduce our fantastic guests.
That's right. We have, drum roll, Sean Stokes and Casey Lide from the noted law firm Keller and Heckman. Now, Sean and Casey have been advising communities across the country on telecom law. They've been doing it for 2 decades, previously with Baller, Stokes, and Lide. And we would like to welcome them to the show. Let's bring my name twin and Casey to the center screen. How you guys doing? Welcome.
Good. How you doing?
Very good. Always glad to have another Sean around.
Casey, good to see you as well. So I think we should just dive right in and start at something that is something that we track quite a bit and something that you are experts in, but on state level barriers and authority. So why don't we tee up Sean Stokes, and let me just start by just asking you to start with the foundation. When a community wants to build broadband, what is the source of that authority, or what is the source of the authority it should examine first?
Sure. So it's a really good question. It's a really foundational question, and it's because as a governmental entity, your authority is not necessarily intuitive to engage in broadband or other types of communication services. And it really is going to depend on what you want to do and how you want to get there. But generally speaking, even though federal law may allow you and may in some instances actually encourage you to get involved in the broadband communication space, it does not itself authorize you. You actually have to look to state law to find your authorization. And that, in fact, has been litigated out. In fact, we are involved in 2 of the main cases that involve the litigation. And that's primarily comes down to the fact that even from a policy perspective, if the federal government wants to encourage local government entities and municipal entities to get involved in the broadband space, because they are political subdivisions of the state, and that is such a quintessential function of states in terms of administering their own political subdivisions, unless Congress gives explicit authority in words of one syllable, which has not yet done so, you have to look to state law for that authority. And I would also note that you need to look to state law for both substantive and procedural requirements in terms of how you can exercise authority, when you can do it, what are the means of exercising that authority. And that applies to every particular service you may want to provide. That means that if you want to be a broadband provider, what's your authority to do that versus a telecommunications service versus a cable television. And we see various restrictions, as Sean, you referenced, there's around 16 barriers.
Right, because I was going to ask you to talk about the types of state laws that commonly restrict or condition municipal broadband.
Exactly.
Yeah. Go ahead.
Yeah. So there's very few states that actually have outright prohibitions. Usually they tend to be barriers that you can, the good news is they are ones that a lot of folks have found ways to work around, although they are just that. They're barriers that make it more difficult to work through. And sometimes it's a death by 10,000 cuts. The good news, though, is that there have been less of them over the last 3 or 4 years. We've even had a few states remove some of the remaining restrictions in their states. Arkansas, for example, removed Washington. Washington State, et cetera. Colorado removed some requirements. So I think that's the good news. The other part about it is that there are ways to work through all these, but you just need to be aware of where those sources of authority come from and how they interact. And then the final note I just want to make, and this is very much in the weeds, we won't go into detail on it, but there's a continuum of something known as Dillon's rule states versus home rule states. And the easiest way to view that is Dillon's rule state at the far end is you can only do those things that the state specifically says you can do in the legislation. The far extreme of that is a home rule state, which means basically you can do anything other than what the state specifically says you cannot do. And you've got different variations within each state, and you just need to look at how home rule versus Dillon rule is interpreted in your particular state.
So, Sean, you alluded to the fact that some states, some communities have figured out a way to kind of get around some of these restrictions. How do they do this? Can you maybe give us a good example of a community that has basically, navigated around the restrictions in their state law?
Sure. So, for example, Texas has had one of the longest standing barriers to community broadband projects. But when it was drafted, broadband was actually not much of an actual service. And so the restrictions on their face only apply to regulated telecommunications and cable television services, such that that incumbent telecommunications carriers and others that are certificated by the State Public Utility Commission in Texas regulates. So, for example, FAR, Texas, and some other communities have been able to find that, no, we can actually provide broadband services, because broadband, as we all know, even the current FCC says is not a telecommunication service. And Texas law similarly says it is not a telecommunication service. It may be a vitally important type of fourth utility, but it is not a telecommunication service. And those folks have been able to do that. Another one that's been able to do that is Missouri, which also had a restrictive law right from the beginning, but it has a huge gap in it, which says that municipals may provide internet-like services. And I will tell you that Casey and I can find a lot of driving room in the phrase internet-like services for someone to be able to provide services.
Well, I'm delighted to know that the demise of Title II has some actual good results since I've.
You can always find a rose someplace among the thorns.
So one other last question for this section anyway is what are some persistent myths about what communities can and cannot do legally, right? People shake a lot of the incumbents, they shake the litigation sword and folks freak out. What are some of the myths that they throw out there?
Yeah, and I invite Casey to jump in on this too. But a number of the things that you hear as legal challenges, I just start out with this. A number of the things you hear as legal challenges are not legal. They're policy, they're political, and as governmental entities, you have to deal with that political side of it. But those are more PR battles than actually legal. When you dig into it, maybe you have to jump through certain hurdles. You have to do certain types of things. There may be a mother may I process where you have to go to the incumbent and ask them to do certain things, but it is not a restriction. And yet quite often these are couched as, well, you may not do this. And the state law does not say that.
Yeah, from the PR perspective, you hear the phrase often, they're using taxpayer funds to compete with us. And that's, 9 times out of 10, at least, that's not the case, I would say. And even where it is in the case of like a general obligation bond or something like that, there's a lot of nuance involved. That's not strictly a legal issue, but it's, that's something you see pretty often.
Yep. The only other one I'd say is that competitors should not compete with those that they regulate. First of all, government entities are conservative from the point of view of small c, of they are risk averse. They're not going to just jump in to do things. They think about these things almost always. They get into this space because the need is not being filled by competitors and third parties and choice. And so when you look at these are almost always structured as ways to facilitate competition and providing additional services and capabilities to these communities and providing the fundamental infrastructure for moving these communities forward. As we always say, the analogy to this was electrification back 100 years ago.
Yeah.
I can attest as somebody who's spending a lot of her time trying to encourage communities to move forward. Nobody takes this lightly. It's a big financial decision. It's a big political decision. So nobody's just like waking up one day and saying, oh, I think we need community broadband for our community. It has to be a very well thought out process, and sometimes takes years or even longer for folks to actually move forward. So anyway, let's move to the next section. Sean, I'm going to turn it back over to you.
So we should let's spend a few minutes talking about governance and ownership models. So let's start with Casey here. So we've got municipal networks, we've got municipal utilities, municipal authorities, cooperatives. What's the difference between those legally?
Well, yeah. From the first point, a cooperative at least is a private entity. It's not a municipal entity, so that's a pretty fundamental difference. The other two, municipal authority is sometimes a quasi-governmental entity, but it's mostly on the municipal or governmental side of things, and obviously a municipality is a government entity. So they're very different in some fundamental ways, but they also have some commonalities. Like we were just saying, a municipality doesn't get into this unless there's a reason to do it, right? They're generally not going into it to make a bunch of money next quarter or what have you, right? That's a kind of a similar game for the cooperatives too, or electric cooperatives at least. So usually, their core mission is electric service or sometimes telephone service. But at least in the case of the electric cooperatives, they don't wake up one day and say, that they want to provide broadband unless there's a real need there for their constituent members / customers to have it. And fortunately, they're often in a position, having excess fiber available and what have you, to be able to meet that need. But it really, it comes down to what is the need that is trying to be met? What is the really high level objective for a municipality to consider in looking at this issue? I mean, we talk a lot about economic development, but I think you really need to dig deeper than that. Economic development, does that mean you're trying to enable competition? Does it mean you're trying to simply improve residential service and try to keep young people in the community? Are you trying to attract businesses in the sort of a pure economic development perspective? Is there a data center coming up nearby that you want to be able to try to serve or something like that? So you need to dig a little deeper than just, we're going to improve the economics in the area. Going a level down from that on the governance models, communities should think about issues of control and how comfortable they are with the various degrees of control over a project. Do they feel the need to own the infrastructure themselves? Or is it something where they can go into a public-private partnership where maybe somebody else owns the infrastructure and there's some other arrangement in there? Do they want to have total control, or can they be more passive in sort of facilitating development by a private partner potentially? I need to think, very frankly about what the community's capabilities are. Some communities may have a public power utility, in which case they've already got some infrastructure to go out there and do this kind of thing. They may have poles. They're likely to take a more active role, I would say, in a project than a community that may not have that capability kind of already baked in their history and in the way their departments are set up and such. It's also important to consider, is there a potential partner in the picture already, assuming you're going in any kind of partnership route? Is there somebody who's, maybe approached the community and said, hey, we think we can help address some issues here and let's see if we can do it together? Is there somebody local who just kind of fits the need? And also, it's important to consider whether you should, go to the incumbent first and say, here's what we'd like to do. Please do this. Can you help? And at the very least, you'll hopefully get an answer no or yes, in which case problem solved, right? If they say they can, but if they say no, then you've tried, right? And that can help you a lot down the road.
Gigi, you want to jump in here?
Sure. So how do these models affect authority, economics, access to rights of way and public facilities, funding opportunities, and regulatory burdens? So can you break down the different models that Sean laid out and set in and kind of talk about, the different responsibilities under each one of those?
Yeah, and I'll invite Sean to chime in too. This is a big question. I think there's a lot going on here, but if you have a municipality that is, and let's talk about it from control perspective, I think that may be a good lens to look at it. If you have a municipality that is doing all of it itself, owning the infrastructure, providing the service, then that puts that municipality in a position to be where it could be more problematic with some of the barriers to entry that Sean had talked about, as opposed to a municipality who may simply own the infrastructure and then grant an IRU to somebody else
to
actually provide the service. An IRU is an indefeasible right of use, which is a lot like a lease. It says, here I have this property, I'm going to effectively rent it to you, but an IRU is a little bit farther than that. It's about as close as you can get to an outright sale of property without being a sale. It's a right to use the property for the theoretical useful life of the property and generally pay it all up front. So, between those two, bookends, there's a lot of room in the middle based on the various models, but the more aggressive or more control focused the community is going to be, then the more they have to consider these authority issues that Sean mentioned as well. And all of this is going to drive the structure on how you from the get-go, are you, is it a public-private partnership in some way? Who is going to be, who owns the customer? That's kind of a fundamental question that is really good to ask up front. Who's going to have that customer relationship? And then that usually guides who's going to have the vendor relationship. Or if you're offering voice over IP, are you going to be contracting with a managed voice over IP service provider? Or is your partner going to do that? And so there's a really fundamental things that can, should be considered pretty early on in the process.
Yeah. So now, Sean, I don't know if you've got anything to add, but we should talk about public-private partnerships. Sean, did you have anything that you wanted to add before we?
Sure. I mean, and I can actually fold that into public-private partnerships briefly. I should also note that, and we do this as much as anyone, these are often referred to as public-private partnerships when they're sort of small P's here, that they are contractual relationships between a public entity and a private entity, or two public entities, et cetera, or in the case of a co-op, it could be a private and a private. And they're not like what people consider public-private partnerships in the sense of, say, someone's building a turnpike system or an airport, and how those are worked through. As Casey indicated, some of it will be, they will have IRUs granted to one another and all sorts of structural agreements and contracts, but they're not partners in the sense of that they are responsible for each other's into each other's vested interest in business. And so what you often will work through, depending on what you want to do and how you get there, is looking at private entities in these types of relationships, and public entities often have asymmetric goals in a good way. Asymmetric goals meaning that maybe the local government has a long-term view, as most government entities. They want to get these capabilities out there. They're not necessarily looking for a fast return on their assets, or what often is referred to as they've got patient capital as they're building this out. And it's sort of they're looking for generational investments in building this. So they can structure agreements with a private entity that through, say, a lease of fiber, and if that private entity is going to be the service provider and responsible for compliance and other types of things, that they would, as Casey said, maybe they would pay some funds up front, maybe they'd pay, there'd be a revenue share, other types of things where it's structured as this long-term relationship between the parties. But you really want to nail down who's responsible for each part of it. Is this party that's the private entity, are they acting as your agent, in which case you are the actual provider, you are the entity that's responsible for it, but they are providing the service, or they actually know they are a standalone service provider that is using your facilities and infrastructure, and there's a continuum in there.
Yeah. One area of tension, if I can add a little bit to that, between communities and a private partner, where the private partner is the one doing deployment. Let's say they're extending the network, or you have a mutual objective to serve an area, is that, naturally the private partner is going to want to go to the more profitable areas first, where it costs least to deploy. And the community may not have the same agenda, right? They may want to serve the people who are in most need, and those are often diametrically opposed. And so resolving that issue can be is often a source of tension.
Yeah. And so let's spend it for this next little part. Let's just spend a few minutes talking a little bit about public-private partnerships, which, from our perspective, I think there's actually a lot of interest in that, because I think a lot of communities are, hesitant to, quote unquote, get into the broadband game themselves, at least from a retail perspective. But, from our perspective, we tend to be fans of public-private partnerships where the local community maintains ownership of the assets or the network, to at least to a large degree. So let me just ask, and maybe start with Sean Stokes here. Where do communities in public-private partnerships gain flexibility, and where do they give up control?
Right. So let me back up one step. For quite often, government entities, when they're engaged in these types of activities, need to go through a procurement process, and because guidelines are set out about how they spend money and select a potential partner, and that's for both constructing the network and operating the network, and how you want to do that. And so some of those things will be laid out through the procurement. Are you going to go out for a request for information or request for qualifications, laying out we will own the network. We're looking for a partner that will build this, operate it for X number of years, provide the following services and capabilities, et cetera. We will, as Casey talked about with an IRU, which is often the vehicle that's used for this, we will own it, or any facilities that are built that at the end of the term, if the parties go their separate ways, it will revert back to the municipal. That's one form of control. The other place where you look for forms of control is, and this is a little bit of a tension you sometimes with private partners that you have to work through, is they are quite often building these networks with an assumption or hope that somebody larger will buy this or purchase it, or some other equity entity will come in as part of the larger network. We saw this when Google was building out in a lot of areas in the Kansas City metro area in the early 2010s, that people were starting to build little pieces around it in hopes that Google would acquire them. Well, of course, the local government entity may want to have the scale and volume of a Google assets connected to their network, but they want that network to still maintain to be the public entity's infrastructure and to own and control. And so you don't want to have the ability for your partner to swap out a new dance partner on you, changes of control, how those type of work. And so you need to work through those, and what your level of control and ability to maintain that, and yet still allow that private entity to have the flexibility to get the funding and capabilities that you want them to do, to incentivize them to come in. And that's where the trade-offs kind of come into this.
Yeah, I think you've kind of answered the question I was going to ask about legal risks, particularly if, the dance partner decides to leave. So let me ask a different question then. Like, who actually owns the customer relationship? And is that legally significant? And if so, why?
Casey, you want that one?
Yeah. I think it varies. It depends on how it's set up, right? You can have a situation where especially in a public-private partnership, where the municipality, like we were talking about, maybe grants an IRU to a partner, and the partner says, all right, we're going to go forth with the support of the community, and we're going to build the last mile, and we're going to build the service drops, we're going to be the service provider. In that scenario, it's easy to see where that partner would quote own the customer relationship. Maybe they're providing a revenue share back to the municipality or something like that in their financial model, But in that scenario, I would think the private partner would own the customer. There are various levers that the community might have on that. Again, like we talked about in terms of deployment commitments, they may have some input on services that are able to be offered, and maybe they have some input over pricing and that kind of thing. But you know, by owning the customer relationship, that entity would you know, they're the service provider that carries with it the next level some regulatory issues, right? If they're providing voice over IP, then they've got to be concerned about a raft of regulatory issues at the federal level. And depending on the services they're provided, possibly the state level as well. They might need to be certificated with the State Public Utilities Commission and such. And the same is true if the municipality is the service provider as well. If they have no partner, if it's structured in such a way so that the customer is, quote, owned by the municipality or the community.
Right. Yeah. The other thing I was going to add on that is, and that's why sometimes you'll see particularly more discussion nowadays about open access networks, where the entity, whatever it is, a co-op or municipal or the partnership, builds the infrastructure and they bring it to, there's various models of where they bring it to, but essentially they bring it to the individual customer's location, and then the customer then can select who the individual ISP service provider will be, and they can, and select among those and change that. And that, in that situation, the end user customer has a relationship with the network owner to allow the physical facilities to be installed there. But then on the other side of the demarcation where the service is actually provided, the individual ISP that has been selected owns that customer relationship. And that may make sense in certain areas. What you don't want to have is something that sort of a regulatory structure from the state down that is imposed that prevents you as the owner of that network from making sure that the people that are providing services over your network provide good service. And so you don't, that Washington State had some problems with that for years, was that they were mandated that public utility districts, for example, could be in this space to operate open access networks, but they could have no customer service relationship to make sure to ride herd over those ISPs that were providing service over their network. And that left a bad taste in their mouth sometimes if an ISP didn't do a good job, but the owner of the network couldn't say anything about it.
Yeah. Let's you mentioned Sean, excuse me, Casey, you mentioned finances a moment ago, and so let's pivot into financing and funding compliance. And let me just ask you, what legal considerations come into play when you're financing a broadband project with bonds?
Well, I'd start by saying we're not bond counsel, and bonds, it gets pretty complicated and down the weeds real fast. So I'll be fairly quick and high level with this. We work with bond counsel on these projects from time to time and have a lot of respect for them. It's generally not our ball of wax in a way. I can say that you do run into issues sometimes with the degree to which bond proceeds can be used to support activities of a private entity. And so some states have constitutional provisions that bear on that, and that dates back to the early railroad days, actually, when municipalities pledged support for certain railroad deployments, and the railroad bust, and it caused a lot of problems for the municipalities. So there's some issues to be navigated with that, but it varies a lot by state. My overarching recommendation would be, find somebody who really knows what they're doing when it comes to bonds, because you have to talk about general obligation bonds and revenue bonds, all of that. There's various models involved, and you need a real good financial expert to walk you through those issues, I would say.
Gigi, you want to jump in there?
Can we pivot to grants for a minute? Because obviously that's a lot of people's minds. So how do federal and state broadband grants introduce additional legal obligations?
Yeah,
go ahead.
Sorry.
Please.
Not surprisingly, there's quite a few compliance obligations involved, right? I mean, apart from the deployment obligation, right? You get grant funds to deploy to broadband serviceable locations, and you have to do it at a particular period of time. That's one level of obligation that you've committed to by taking the grant funds. And there are not surprisingly, a fair amount of reporting obligations, things like letters of credit and security instruments, all of that those of us who've been following, BEAD and RDOF and all the way back to BTOP are, know and love. Some people view those requirements as being so onerous as to make it not even worth participating in these grant programs. So it's not to be taken lightly. I would say, one side of that I think does not get enough attention is the federal interest. And real quick, the federal interest is the federal government has effectively a lien or a property interest in property that is acquired or improved with grant funds. So that means if you deploy a fiber network using grant funds or use your matching funds to do that, then the federal government has a claim over that property for a period of time. And the practical effect of that, it mainly comes into play if and when you try to sell it. So at that point, if it's within the federal interest period and you try to sell it, then the amount of proceeds you can get for the sale are limited to what's called the non-federal share, which is a percentage. And so you get the percentage of the fair market value calculated by the non-federal share. That's all that the grant recipient can receive if you try to sell it. And you generally have to get agency approval for the sale. And unfortunately, the agency approval for the sale they tend to want to look at that only when all the documents are all put in place. So you negotiate a complicated deal over the course of months and months and months. You may even have an asset purchase agreement ready to go. Everything's all wrapped up in a bow. Everybody's about ready to sign. And only then, thus far at least, we'll see how the agencies do with BEAD. Only then can you go to the agency to get agency approval for the transaction, which then adds on 3 or 4 months at the very end of the process.
Right.
So,
thank you for that. I mean, we should move on, but I just will say, and we don't need to get into this, but just hearing you say that reminds me of that. It also seems like the mechanism by which, so for example, when NTIA recently asserted that they had the authority to withhold BEAD funds if states passed affordability legislation, I would imagine that is the thing that stops states from saying, okay, we won't pass any and then get the BEAD dollars and then pass something and then be like, that's too late, we already have the money. I mean, that seems like the mechanism to
one of them, right?
Yeah.
Yep.
So let's step into some of the regulatory and operational risks that you deal with. So and we should maybe start with Sean on this. Pole attachments and right-of-ways, like nobody ever thinks about this, but they are a big sticking point and pain. They seem to be these persistent challenges. So what should communities understand about kind of the hat that a municipal entity is wearing when it comes to pole attachments and right-of-way issues?
Sure. Yeah. Pole attachments and right-of-way are a cause or cure for insomnia. So broadly speaking, the issue comes down to just what you mentioned, Sean, that if you are in the space of wanting to own and facilitate broadband deployment utilizing the rights of way or poles and infrastructure, it seems like a no-brainer from the point of view of, hey, we've got these assets, they're right here, let's go deploy them. But wearing your regulatory hat, those are the same assets that other providers, whether they're currently there or not, have the ability and want to utilize those also. And so what you have is a tension from utilizing infrastructure that you have ownership of to meet your broadband challenges, while at the same time doing so in a non-discriminatory manner that allows third parties to utilize it. Now, at the federal level, there's not a requirement that you install or construct additional facilities beyond what you already have. In other words, you don't need to put in new conduit or put in new taller poles if you're already utilizing it. But if you've got existing space, but you're sort of working through, kicking the tires, do we want to get involved in doing broadband? You cannot say, hey, that conduit is off limits for the next year while we decide whether we want to use it. If you've got someone else who wants to get in it, and that's where you run into a number of issues. The other part of it is local government entities for years and years have been in various types of business activities with their own operating units where they don't necessarily pay each other fees, but they give each other in-kind capabilities, services, things in lieu of franchise fees, et cetera. In this space where you're actually going to be potentially actively competing against a third-party commercial entity, you really need to monetize, have an awareness of what the costs are and account for those. And it's really just that. It's accounting, just like any other business. If you're going to raise your hand and say, we can operate in this space just as well as a private entity, in fact, in many cases better, that's great, but you need to track your costs and things like a business. And if you're allocating space on a pole for your commercial broadband division, that's fine, but that's not given to them for free. There's a cost part of that you need, even if it's left pocket money from the left pocket and going into right, it still needs to be accounted for. And that trips up a lot of local governments just because it's not something they've historically had to do.
Mm-hmm.
Let me ask, in a lot of these situations, like opposition is inevitable, right? It might not lead to litigation. But again, you talked about the PR campaign. So what steps should communities take before opposition emerges? Like what kind of prophylactic measures can communities take to try to stave off? They may not succeed, but how can they sort of build the case and kind of put off that kind of opposition, or at least make that opposition a lot weaker?
Well, I'd start off by one we mentioned earlier is it may well make sense to see if the incumbent provider can take care of your needs first, and go see if they can help. So that helps in a lot of ways. Maybe they actually can, and the community doesn't need to do the project potentially. More likely, I would say, is that it gives you the ability in the future to say that you tried.
Yeah.
Anything else? Any kind of, policies? Go ahead.
You want to touch base with all the community stakeholders, and you want to get that buy-in. Chattanooga, before they build out their, gig city broadband network, they went around and the mayor and others, city council, went and spoke to business, large and small, and anchor institutions, banks, hospital, education, libraries. What do you actually need for this? And they developed that record, that there was a demonstrated need for it. And it's a little bit of the same part of what Casey's talking about. It definitely shows the need and the basis for why you're doing it. It also creates an inoculation for some of the PR. Why are you doing this? And again, particularly these often gets framed as private versus public or government versus private. When in fact, this is facilitate private businesses, and particularly if you're doing a public-private partnership. But even if it's purely a public entity owning and operating it as a retail service, there are still so many touch points that benefit the private economy there. This is not, if anything, it may be incumbent versus everyone else trying to get the services you need. So I think that's part of it, is don't just develop everything at the front end. The other part of it is, shore up what all your, like I said, the authority, but also what your levels of agreements are. You wouldn't believe the number of times that people get tripped up over something that says, oh, we've got fiber that we're allowed to utilize over here. And then you dig into the contract and it says, oh, we got that actually from Comcast for private, for institutional use. And we're specifically says we can't use it for commercial purposes or things like that. You just need to be aware of them. And then the final thing I want to say on this, and because anytime you hear the lawyers, it sounds like we're saying the doom and gloom. There's a lot of challenges here, but these are things that a lot of, as ILSR and AAPB can attest, are thriving, these networks, and people have gotten through it. You just need to be thoughtful how you do it. And there are challenges on it, but everything, worthwhile is, but we're not saying don't do this or throw in the towel or it's too difficult. It's just, you just need to be aware of these things. I just want to make sure that we're not coming across as saying this is, I wouldn't do this. It's a legal challenge here. I think there's ways absolutely to get through this. And a lot of folks have done so successfully.
Can I just make one other comment on the public-private? let's not forget that the incumbents take an enormous amount of taxpayer dollars to build. What is BEAD? I mean, do you know who the biggest winner is in BEAD? Comcast.
Yeah.
So when they say they're pure private entities and public is competing against them, to me, that's a colossal joke. So that's just another point to be made. But I think we want to dig a little deeper, Sean, into some questions. And this is fantastic so far. So I'm enjoying it. I'm a lawyer and I'm learning stuff. So
yeah, this is a lot to take in very clear responses. So yeah, let's dig into our grab bag, I guess, and have a little bit dig a little bit deeper. And I think we've hit on this in bits and pieces, but what legal mistakes do you most often see communities make early on?
You know, I'll take an initial stab at that. And you know, I know you asked about legal mistakes, but honestly, I think one of the biggest mistakes that we see aren't legal. It's more political or competition related or incumbent pushback or financial in the business plan. That's kind of, you know, where we see a lot of issues, perhaps even more so than the legal. On the legal side of things, we've talked about a lot of things that can potentially trip up these kinds of projects. I do think the competitive neutrality issue is one that really needs to be thoughtfully addressed.
Can I ask, when is the best time for a community to bring in legal counsel? And you know, and when you do, like when you show up and when a community says, "Oh, I have counsel," does that kind of you know, show that that the community is serious and maybe puts the incumbents a little bit on their heels? So when is a good time to bring in? When is too late? And you know, are you guys so powerful that you kind of, wow, Casey and Sean are here, so we're not.
Yeah, we whenever we come in, yeah, Comcast is quaking in its boots, right? Just go run away.
That's right. That's right.
That's right. No, I'd say, you know, the obvious answer from the lawyers is bring in counsel as early as possible, right? And I think that's true, but people should realize that bringing in counsel doesn't mean that the counsel needs to be in every meeting you have from that point forward, and that it's going to be prohibitively expensive and everything. You can bring somebody in early on in the process to you know, kind of just ride shotgun a little bit, look over your shoulder, maybe do some red flag review early on, but it doesn't need to be a very involved, a lot of involvement by counsel early on. More would come later when you start dealing with contract negotiations, but I'd say the earlier the better, and it doesn't have to be prohibitively, you know, expensive or resource intensive.
You know, to that point, I just wanted to say that,
yeah,
go ahead, Sean. I don't want to cut you off, but I do want to ask a question about certain kinds of lawyers.
No, I was just going to say, no, I was going to echo that. Yeah, no, I mean, bringing the lawyers in doesn't mean that they're put forward early on. They're just part of the team that's doing this assessment. And, you know, quite often government and co-ops, they've got their counsel that does all their general types of things, or they may have expertise in the utility functions, but they don't necessarily have expertise in these types of areas. And so a lot of times counsel is brought in to sort of back these parts of it, but it doesn't, you know, they're not up there at front aggressively doing anything with the incumbents unless there's a, you know, there's a need felt for it at that time. Now, on the other hand, sometimes it's fun to have the counsel that you can say, well, you know, our attorneys are requiring this, and that gives the local government entities the ability to do, you know, the utilities can point to, or municipals can point to the attorneys. Well, you know, this is the ones we're doing it, but we can work something out on the side. So you can use as you see best to position the attorneys, whether they're forward facing or completely in the background.
Right. So you're talking about the attorneys. And so I want you guys, and this question is a little bit of a loaded question. And I guess people could say, well, you have kind of there's kind of a self-interest here, but it just occurred to me that how important is it to have telecom attorneys versus sort of any old attorney when it comes to these matters? I feel like telecom is a special space, and I'm sure every legal niche would probably say that, but can you talk about that just for a minute?
Sean, you want to?
Well, yeah, I mean, that's a little bit what I was saying before, is a lot of times local governments will have a city attorney. They'll have if it's a utility or co-op, they'll have an electric, and they're experts in government regulation and generalist for everything that's going on in terms of human resources within the city, all the other types of things. But having someone who understands the details of legal regulatory that apply to telecom broadband can save a lot of time. And a part of it, though, is quite often what we do for, say, compliance is we work with teams within the municipal public-private partnership, et cetera, to train them up. And then we kind of go away. We're not there filing everything for them on a monthly basis types of things. A lot of what we do is sort of broadly speaking, use the things that we understand that works from different communities around the countries, and so gives you that scale. And I think that's what the expertise that a good broadband or telecom attorney would bring to it, and understanding and anticipating how these things work. But it would still have to be hand in hand with the local attorneys who understand their own state laws and regulations and requirements, and the political background that we don't necessarily have any view into.
I would just add real quick to that. Telecom can be pretty arcane, and so there's a lot of weird terminology and inside baseball that happens with this, and it really comes to bear when you start doing contract negotiations. And we have a lot of clients who aren't municipalities, and we represent various types of ISPs all over. And so at some point, the community is acting like a telecom provider or an ISP like many others, and they're going to have to do contracts, whether it's leases or IRUs or co-location or what have you. And those tend to be very specialized types of contracts, and there's terms in the industry and approaches in the industry that are kind of known, and it would be difficult to do that unless you have some specialized expertise in it.
Yeah.
So let me ask one last question before we go to audience Q&A. So if you're in the audience, please put your comments in the chat, questions in the chat. Free legal advice, so please do. What would you guys say is the sort of the one legal issue communities consistently underestimate? Like, what do they fail to anticipate? And if you guys can you guys have been giving some really good examples when we're talking about these legal vagaries. If you can give a particular example, that would be great as well.
I would say that they quite often don't speak to all parts of the municipality that are doing things. And so it'll come up as a project, say, in one division of the city, say, and it makes sense, but they're working on it in isolation, and there's other groups that are doing things, and it's moving on. And when you unveil this, it's not as coherent as it needs to be. And so I really, it's not as much legal, but it's just, you got to go back and pull together all the actual stakeholders that are part of this and how it's going to work, because you'll find that, procurement just went out and, you thought that you were going to be serving all of the, build this network, and if nothing else, you'd be serving all the city's departments and their radio system. Well, nope, actually, it turns out we just signed an agreement with Verizon to do all of those things. And those are the types of things. And then related to that is having an understanding of, what are your existing commitments? And this is a legal part, going through those contracts and things. Can you just turn these things over, or do you actually have existing obligations that you need to go through before you can actually turn up your own network and do these types of things?
Yeah, it's shocking to me that one part of government doesn't know what the other part of government
Right.
Anybody who's ever worked in government will know that it's unfortunately a very common thing. So that's extraordinarily sound advice on both ends. So it looks like we have a couple of comments, questions. Sean, do you want to sort of lead off with picking out one of them?
Sure. Let's see. I think we've got a question about whether there's a specific legal checklist for community broadband. That's actually a great question.
Have you guys done anything like that?
Not in the last few years, right, Sean? Not that I can recall.
Yeah. I mean, not a specific legal checklist. I think we've done things where, like, if you're developing a network operating agreement, say you've got a grant, what are the 10 things to make sure you're looking at, or things like that? That would be about the closest. This sounds self-serving, but it is actually true. We can talk about all these types of things in general, but each one of these is unique because each community is unique and the circumstances around them. And so there are templates you can utilize, but very soon, once you get into that, you start to realize we're going to have to make a lot of modifications and changes.
So you'd effectively need dozens of checklists to account for all the variation, I would imagine.
Yeah, that's right. I mean, we do have, regulatory compliance checklists and things like that, and lots of other organizations do as well. It's not hard to find them. But when you're trying to do any kind of checklist or handbook that tries to get into the operational strategies or structures of projects or things like that, you very quickly, come into a situation where a particular decision creates a variable and you have a tree branching off, and it's just you can't address it in a two-dimensional document.
I don't know if there are other questions that we have. I mean, I sort of have one myself, but I don't know of any others at the moment, so I'll just throw it out there. Certainly over the past, I don't know, several years, we've seen like an uptick in these AstroTurf campaigns to really discourage communities from even thinking about municipal broadband, much less getting into it. I guess from a legal perspective, are legal challenges becoming more or less aggressive in recent years?
I think it's less aggressive from what I can tell, and I'll Sean to chime in as well. And maybe that's one reason we're seeing so much of the AstroTurf. Maybe there's less grounds to contest it legally, and so they're going that route. But it seems to me that there's fewer legal challenges than we had 10 years ago or so.
Yeah, I would agree. I think that we may get another wave of them with BEAD types of things where people will do things, but a lot of those will, not that they won't be significant and a headache for the party having to deal with them. I don't mean to undersell that, but a lot of them are going to be really detailed types of things of like, you didn't comply with X or you didn't do that. And we do see things like that. We'll see things with municipal utilities or a co-op that'll say, you are unreasonably favoring your broadband division or your broadband partner in granting access to your poles or something. But it is not you don't have the right to be in this space as the broadband space. You don't have the right to provide services, or you now need to go and get an entirely new referendum or things like that. It's a lot of that has backed off. Partly also, I think there's a value that industry, there's this whole group of subculture of entities that are looking at working with municipalities that has kind of even the side of it where it used to just be the incumbent saying we're the only ones who can do it, because you now have so many new entrants in here who recognize the best course quite often is to work with a co-op or municipal entity or municipal authority rather than trying to take on the incumbent directly.
Yeah, I've been trying to pitch the incumbents on, this is a great business opportunity for you, but I'm not sure we've succeeded necessarily. I had just a very specific question for you guys. Is there any state that has restrictions that you see right now might be ripe to repeal them? I'm always looking, you mentioned Colorado and Arkansas, Washington State, also Minnesota, was about 2 years ago, home of ILSR. Got rid of their restrictions. They were small, but they were significant. Any state that you guys have been doing work in or see might be ripe for an intervention?
Great question.
Michigan, maybe? Michigan is like my obsession. I just don't know.
Michigan's an interesting one though, because Michigan is problematic. What it does, Michigan requires that you reach out to the incumbent first and you have them say whether or not they'll do things. On the other hand, I've heard that Michigan is ultimately not that hard, because from a practical point of view, the incumbents aren't going to be able to, aren't willing to offer those types of capabilities. So there's an element of, okay, fine, we'll go through this process, which we shouldn't have to. It's ridiculous. It's a mother may I type thing. But the fact is, if we're really in an unserved or underserved area, chances are the incumbent's not going to be willing to do it for the cost and the way that we are committing to do it. But I would agree. I mean, I felt the same thing about Colorado. Colorado's was always a barrier from the point of view that you had to have these elections. On the other hand, given the amount that the local governments were winning, the percentages of those, it was hard to say that it was actually a barrier. And there's part of me that says, you know, if you're going to go ahead with a government entity doing something, it's not the worst idea to have the local politics, the local people say, yeah, we're in favor of this. That one's a hard one to fight from a PR point of view. It's the amount of money that you have to put in place to battle the PR. It's not the fact that you had an election.
Yeah. That's a great point. Now, we're getting ready to bring this webinar in for a landing, but before we do, we certainly want to kind of, I don't know, revisit, or if you'd like to sort of frame what are some of the more important takeaways, legal takeaways, communities should lead with today.
You know, it's doable. This is very doable. You know, there's an increasingly long history of communities doing this very successfully, and despite what you may hear from those who oppose the competition. And so go, you know, if you're interested in it, go look around, find some of those success stories. Not everybody is the same. There are a variety of models, quote unquote, but you know, when you really drill down, almost every scenario presents its own factors. And so it's really important to have your own objectives in mind and your capabilities in mind, and go from that premise.
And the only other thing I'd add, and this sounds odd, this sounds Pollyannish, but I actually think it makes sense. At the local level, try and make this as bipartisan as possible, and get it to move through. This should not be a political football. It will also kill any interest in a private party wanting to work with you if they know that the next mayor may go against this type of thing. But I also just think it's one of those ones, you know, some of the most successful early municipal broadband networks were in very red states and very red areas, but they were viewed as essential by conservative majorities of voters and city leaders to give that community what it needed for broadband. And I know we're never going to get away from that at the federal and state level, but at the local level, to the extent that these can be sort of bipartisan, I think that there's a significant value in that.
Yeah, actually, the broadband is one of those things that is one of the more bipartisan issues across the political spectrum.
Yep,
exactly.
Great point.
The early networks, Lafayette, Louisiana, Wilson, North Carolina, Chattanooga, all in red areas. So on the local, when you get down to the local level, people want connectivity, and that there's no color to that. So
yeah, right.
Anyway, Casey, Sean, this was fantastic. Thank you also to Keller Heckman for sponsoring this webinar. We will be sending out some resources to those of you who've watched this, and also to our mailing lists. And this will be available hopefully very soon online for those folks that couldn't come. So thank you to all that came today. And we will look forward to our next AAPB and ILSR Presents.
That's right.
Thank you so much. Thanks for the opportunity.